Hello, good morning. Hi, welcome everyone. I want to welcome you here in the warmest possible way to the Animal Welfare Act at 50 conference, which, as you know, is hosted by the Animal Law and Policy Program, as you see on the screen. But I also want to mention our important co-sponsors, the Petrie-Flom Center for Health Law and Policy, Biotechnology, and Bioethics here at Harvard Law School, with support from the Oswald D. N. Kamen Fund at Harvard University, as well as the Harvard Food Law and Policy Clinic, which is a division of the Center for Health Law and Policy Innovation at Harvard Law School. So with that said, let me say more about the conference. So my name's Kristen Stilt, and I'm the faculty director of the Animal Law and Policy Program. And I want to just give you a short background about the program and what we want to hope to achieve here at our conference. So the Animal Law and Policy Program is just in its second year here at Harvard Law School. A generous gift from Bradley Goldberg allowed me to start the program upon my arrival at Harvard Law School in 2014. And we've just announced an additional gift from Jeff Thomas, which will allow us even more resources and abilities to grow into the future. And this all builds upon the vision of Bob Barker, who 15 years ago had the foresight to make Harvard the first law school to receive an endowment in animal law. So with all of this support, I was fortunate to be able to bring Chris Green to Harvard Law School, back really because he was a student here, to serve as our executive director. So Chris, you want to say hi? Okay. And then I was able to bring Delcy Winders as our first academic fellow. Upon her arrival, or even maybe when we were interviewing her, Delcy said, I've got an idea for the first major conference, and it's to examine the Animal Welfare Act as it turns 50. And we immediately said, that's absolutely right. This will be an amazing event. And we want to thank Delcy for all her tremendous work in making it happen today. In addition, Kelly Reddy joined us as program administrator. Kelly's in the back. Right? Just in time to get the registration page up in August. And this has been her full-time job ever since. And we are very grateful. But let me say a few more things about our program team. We also have graduate scholar, SJD candidate Jessica Eisen, here sitting in the front. And our newly arrived policy fellow, Alice DiConsetto, who's working on animals and agriculture. You're here, Alice, in the back. Right. And we're also grateful to John Lovorn for contributing his time and experience in teaching our course in wildlife law, which he's taught twice now, as well as David Wolfson, who'll be teaching a new course on farmed animal law and policy next year. And finally, I want to thank our incredibly active SolDev chapter. That's the Student Animal Legal Defense Fund chapter. For their enthusiasm and engagement, and for helping volunteer here today. And I just want to say, personally, it's truly a pleasure to work with such smart, creative, compassionate, and truly wonderful people. It makes this position here truly fantastic. So the Animal Law and Policy Program has held several academic workshops over the past year, but this is our first major public conference. And one of our intentions here is to host events in which we can carefully and deeply examine a topic from all perspectives with as broad a range of participants as possible. And that's our goal here today and tomorrow. And a central part of our mission is to provide an academic forum committed to the rigorous exchange of ideas, with the goal not only of advancing knowledge for its own sake, but also using that knowledge to create new solutions in the area of animal law and policy. And we very much hope that our conference today does this. We want to push ideas, ask questions that aren't being asked, and do things that no one else is doing. So finally, I want to say we're very fortunate to have the committed institutional support of Harvard Law School, and as well as my dean, Martha Minow, who will be sharing some remarks with us at lunch today. And finally, then, Chris has a few logistical announcements to make before we start with our first session.
Hi, everybody. Thanks for coming and joining us here today. I'd just like to start off by thanking Professor Kristen Stilt for her amazing leadership of the Animal Law and Policy Program Truly, if it wasn't for her, none of us would be in this room right now. So please join me in thanking Kristen. So a couple quick housekeeping notes. Most of you should be able to log on to the Harvard University Wi-Fi system without needing any password or anything like that. If you have any problems, just ask at the registration desk. A bit on the format of each panel. We're going to give each speaker, it's going to take about 15 minutes and do a short presentation. Then we're going to have a full half hour for an actively moderated discussion led by moderators that were selected. And then about halfway through that, they're going to start taking questions from the audience. For those, you each have on your table some pens and some index cards. So once the presentations are done and that final half hour starts, just hold up your index card, and we've got volunteers that will come by and be collecting those and bring them up to the moderator. Anyone have any questions? So just write them on one of the cards and someone will come grab them. I'm kidding. With that, we're going to turn, and also just so you know too, we're going to do very short introductions on these panels so we can leave as much time as possible for actually engaging into the conversations, and you can go read the deeper speaker bios that are in your packet. So with that, I will turn it over to our first moderator, Delcy Winders of the Harvard Animal Law and Policy Program. Thank you. And then these are down here. So whoever's first.
Okay. I might need help just because I don't use Macs, but I should be fine.
So who's first?
Kathy Liss.
There we go. And then.
I'm just going to call everyone.
Oh, yeah, sure.
Yeah. Good morning, everyone. Welcome to our first panel. I'd like to call up all of our panelists for our first panel, which is on standards under the Animal Welfare Act. We'll hear first from Kathy Liss, who is president of the Animal Welfare Institute, and we'll be talking about engineering standards versus performance standards. And as Chris said, we're going to do very brief introductions. There are full bios in the program. These people are very accomplished, and we would spend all day if I was going to go over all of their qualifications and expertise. After we hear from Kathy, we'll hear from Kimberly Ho-Keane, who is senior attorney for companion animals with the Humane Society of the United States, and she'll be talking about standards for commercial dog breeders. And then we'll hear jointly from Naomi Rose, who's a marine mammal scientist with the Animal Welfare Institute, and Georgia Hancock, who's general counsel for the Animal Welfare Institute, and they'll be talking about marine mammal standards. And then finally, we'll hear from Anna Frostick, senior attorney for wildlife and animal research with the Humane Society of the United States, who will be talking about the regulation of infant exotic animals under the Animal Welfare Act. So Kathy, if you could just get us started. Thanks very much. Okay, I'm technologically challenged. You have to show me where I advance it. I believe. Yeah, so you'll just use the clicker there. Yeah. And just will be keeping time. So she'll tell me 5 minutes. Right there. Got it. Okay. Okay. Good morning. Let's get started. Greatly appreciate the opportunity to participate in this exciting conference. I'll be speaking about the shift from engineering to performance-based standards following passage of the 1985 Improved Standards for Laboratory Animals Amendment to the Animal Welfare Act. And I'll also touch on the ongoing threat posed by regulatory reform movement. For those who aren't familiar with the Animal Welfare Institute, here's a brief summary of our work, particularly as it relates to animals in research. As you can see, we certainly sought adoption of the original Animal Welfare Act. I'll admit that one was before my time, and various amendments thereafter. And my involvement with the organization began as the work for lab animal standards happened in the early 1980s. We published a book, Comfortable Quarters for Laboratory Animals, and last year published the 10th edition. We make it available free of charge to laboratory personnel to assist and inspire them in making improvements in lab animal care and handling. What is perhaps somewhat unique about our organization is we reach out to individuals within research
try to provide them with tools to help improve the condition for animals there. As you know, the Animal Welfare Act is the chief federal law for the protection of animals. We seek to ensure the best possible implementation of the law. These are some of the key tenets, and certainly there's room for improvements in each of these areas. All we see is vitally important. As I was saying, I began work for the Animal Welfare Institute in the early 1980s, and this is a time when small, barren caging of animals was commonplace. Social species, including dogs, primates, cats, and rabbits, were typically confined to single cages. Enrichment was nearly non-existent, viewed by labs as both costly and a source of extraneous variables. Laboratories seeking to maximize use of space have commonly housed animals in tiered cages. In addition to the space constraints for the animals, this makes observation of and attention to the animals in the lower dark cages much harder. There were many issues that cried out to be addressed via legislation, such that in 1981, there were 7 different federal bills on regulation of animal experimentation and use of alternatives pending in Congress. And in that same year, they were considered at a 2-day-long hearing. 4 years, 3 hearings, and numerous bill iterations later, we ended up with Senator Dole and George Brown introducing the Improved Standards for Laboratory Animals Amendment. Each step of the way, the research industry, led by the National Association for Biomedical Research, sought to kill the legislation, and barring that, at least weaken it to the best of their ability. Nonetheless, on December 23rd, 1985, a bill was signed into law. It requires investigators to consider alternatives to any potentially painful procedure, establish the Animal Welfare Information Center to provide data on alternatives, and training also for laboratory personnel, mandates institutional animal care and use committees, including a veterinarian and an unaffiliated member intended to represent the community concerns for the welfare of the animal subjects. And oftentimes, that description of their role is left off, and they're referred generally as an unaffiliated member. And of course, we had the requirement for exercise for dogs and a physical environment to promote psychological well-being of primates. The requirement for primates was in at the behest of Senator John Melcher, a veterinarian. Having seen laboratory chimpanzee cages, he characterized them as, and I quote, extremely efficient, extremely expensive, and extremely cruel, end quote. Although we prevailed at passing the bill, much of the battle still lay ahead. Having failed to prevent its passage, the next scheme by the enemies of the act was to delay promulgation of regulations as long as they could, and they held the process up for years. Final regulations were inevitable, so the battle honed in on the content of those regs. Initially, USDA proposed regulations referred to as engineering standards. That is, they describe requirements that need to be met in order to achieve a specific outcome. These were attacked by the biomedical research industry as being too rigid, costly, and burdensome. As an alternative, the industry proposed performance standards, whereby instead of mandating what must be done, the outcome being sought is defined and the means to get there is left up to each regulated entity. Reagan-era executive orders came in handy for them, such as 12291. These were effective weapons in their attack on engineering standards, claiming undue and costly regulatory burden in need of a cheaper alternative. Meantime, on the one hand, the research industry offered inflated cost estimates, and certainly there were individuals that I had discussions with who were encouraged, well, you know, you might have to do this and you might have to do that, and what they could to bring up the cost. All the while, from our perspective, we were seeking to facilitate this change at minimal cost. And one idea might be the notion of taking 2 primates that were singly housed and opening up the cage wall between them and allowing them to at least have each other's company without necessarily having to mandate new cages. Not that it wouldn't be nice to have larger cages, but let's get things moving and at least have them have each other's companionship. To support the performance-based approach, the industry also embraced a 1983 report of the Presidential Task Force on Regulatory Relief, which states in part that health, safety, and environmental regulations should address ends rather than means. Ultimately, industry prevailed. Final regs adopted by USDA nearly 6 years after the law was passed rely heavily on performance-based standards in fulfilling the new mandates for dogs and primates. In essence, for dogs, if they're kept individually in cages, they require exercise. The regulations for exercise of dogs allow the dealer, exhibitor, or research facility to develop their own plan regarding the frequency, method, and duration of the opportunity for dogs to exercise, as determined by the attending vet and the research facility's Institutional Animal Care and Use Committee, which must be consulted and give approval. By contrast, what we would have liked to see would have been an engineering standard that could mandate daily removal from cages and perhaps set a minimum amount of time for them to be in a room outside of the cages in an exercise area, perhaps. Meanwhile, the cages could be cleaned and dried. Again, there need not be tremendous additional cost. For the psychological well-being of primates, again, there was the need to develop, document, and follow a plan for environmental enrichment to promote psychological well-being. The plan must be in accordance with currently accepted professional standards as cited in appropriate professional journals, reference guides, and as directed by the attending veterinarian. The plan must include specific provisions to address the social needs of primates. Critically, exceptions are allowed. In 1996, after 5 years of the law being in effect, USDA inspectors were surveyed to see how it's going. They found that there was much confusion, not surprisingly, about what the regulated industries should be putting into their plans. What should they really be doing? What does this mean? And the USDA inspectors needed guidance too. As they were reviewing the plans, they had no idea whether they actually were appropriate or not. In 1999, a draft primate policy prepared by a team from USDA was published for comment in the Federal Register, and my hat's off to the individuals that did that. The draft policy was described as the current accepted professional standard for promoting psychological well-being of primates. The background work that they did was extensive, included review of primate literature, professional journals, reference guides, discussions with veterinarians, primatologists, and USDA inspectors. The policy offered a detailed framework on what should be in primate plans. In essence, what the institutions weren't doing, they took on themselves and did for them. It was never finalized. Why? I would suggest that industry much prefers to keep it vague. Performance standards have allowed the industry to self-regulate, with each facility doing its own thing. And for many, that meant maintaining the status quo. Plans are supposed to be in accordance with currently accepted professional standards. But whose standards are those? USDA's? The institutions? What profession? There are regional, institutional, individual differences. How does cost affect the standard? The performance standards are ambiguous. If the plans demonstrated a sincere and thorough approach to promoting psychological well-being, they wouldn't have to be kept from the public. Since the plans are held at the facility, not sent to USDA, its inspectors must read and review them while they're on the premises only. This leaves the public and the humane community in the dark. Accountability isn't possible without transparency. How can advocates hold research facilities accountable for what they do or don't do for primates if we don't know? And how can we be certain that USDA is doing the job it should of ensuring that the primate plans are thorough and appropriate? And it can get worse. Donald Trump will be sworn in as the 45th President of the United States on January 20th. Here are some agenda items from his website. He speaks of eliminating various regulations, decreasing the size of government, maybe fewer inspectors enforcing the act. Even if the Animal Welfare Act is not in his sights now, be assured that the regulated industry will seek to bring it to their attention. And for those who feel a sense of deja vu, his plans are very much reminiscent of the Reagan era of deregulation that led to the weak performance-based standards. The Reagan administration also called for a zero budget for enforcement of the Animal Welfare Act for a couple years in the mid-1980s. So steel yourselves for what lies ahead. I'd like to take a moment to respond quickly to the Association of Primate Veterinarians, who did a survey in 2014 on primate housing. Taylor Bennett of the National Association for Biomedical Research touts the progress that's been made in providing social housing under performance standards. First, his data lumps breeding primates in with those primates on active research protocols. Well, of course, breeding animals are socially housed, so that artificially makes the data appear much better than it really is. Why can't we focus on the status of those animals actively in research alone? According to his data, nonetheless, 29 years after the improved standards for laboratory animals amendments, there were nearly 14,000 primates in single housing. Most of these are identified as having some contact, but all this means is they have auditory, visual, and/or olfactory contact. Wanted to speak quickly about friendly contact with humans, which can provide environmental enrichment. Here, a male rhesus presents his back leg for blood collection. Use of positive reinforcement training of primates builds a trust relationship between the human and non-human primates and reduces handling and procedural stress. As USDA is assessing plans, I hope they're requiring positive reinforcement training as an alternative, a critical one, in place of involuntary restraint of animals during common handling procedures. Without a mandate, the transition to this isn't going to happen or will be happening very slowly. The standards in the Act are woefully out of date. So where do we go from here? I hope that we can take the knowledge that we have amassed on the needs of animals and set meaningful, clear, enforceable requirements that will not take decades to implement. And finally, very briefly, separate from my talk, I just wanted to take a moment to recognize a very special person who died last month, Tim Allen. Tim worked as the technical information specialist at USDA's Animal Welfare Information Service, created under the Improved Standards for Laboratory Animals Amendment. Tim had been at AWA for 24 years, and during his tenure, developed and delivered training program for compliance with the Animal Welfare Act by research facilities. He aided countless people in their search for alternatives to potentially painful procedures. He was a champion for the Animal Welfare Act, and Tim will be greatly missed. Thanks very much for your time, just in the nick of time.
Slideshow.
To the top, and it says slideshow.
Oh,
Click from start.
okay.
This one goes to next.
Mm-hmm.
Good morning. Thank you, Delcy. I'm glad to be here. My name is Ho Keane, and I'm an attorney at the Humane Society of the United States, and my practice focuses largely on commercial dog breeders, otherwise known at HSUS as puppy mills. So I'm just going to talk briefly, give a little background on regulation under the AWA of commercial dog breeders, and then talk a little bit about a rulemaking petition that we submitted to improve and upgrade the current regulations governing dog breeders. So first of all, who has to be licensed as a dog breeder under the Act? Anybody who qualifies as a dealer under the Act must be licensed if they're selling dogs as pets in the pet trade. There are a few exceptions to this, including small-scale breeders who have 4 or fewer female breeding dogs. And recently, there were some amendments made to the regulations that now exempt anybody who is selling directly and exclusively face-to-face transactions with consumers. They also do not need to be licensed. At the moment, there's approximately 2,000 commercial dog breeders who are licensed by the USDA, but we think there are many, many more who should be licensed but are managing to escape licensing. Oop. Sorry. In our view at HSUS, many commercial dog breeders can reasonably be characterized as puppy mills, which are essentially breeding facilities where the profit takes priority over the treatment of the animals, and breeding dogs are more or less viewed as machinery to produce many puppies for the pet trade. Common puppy mill conditions include stacked wire cages, inadequate exercise, inadequate veterinary care, limited access to human interaction, and often inadequate food and water. Unfortunately, the conditions in commercial breeding facilities often leads to sick puppies. HSUS hears annually from hundreds of consumers who went to the pet store, bought a dog who was bred in a USDA-regulated facility, and are heartbroken because their dog was sick. A lot of communicable diseases are produced through the unhealthy conditions of the facilities, as well as hereditary conditions which the breeding parent dogs have, and the breeders do not remove them or screen them for these traits, and so they're passed on to the puppies. So it leads to a lot of consumer protection issues, and we actually work a lot on consumer protection litigation for that reason. So in our view, the USDA has the authority and mandate to improve the conditions of breeding facilities. The Animal Welfare Act delegates to USDA the obligation to promulgate standards that govern the humane handling, care, treatment, and transportation of animals by dealers. Unfortunately, a lot of the regulations, the current regulations, many of which were promulgated in the late 1990s, or mid-90s even, do not provide for the, quote, humane care, treatment, and transportation of animals. So it's our view, in fact, that in order to bring the regulations into compliance with the statute, the agency has an obligation to update and improve the regulations. So the current regulations allow for wire flooring, inadequate space, stacked cages, minimum exercise, and there's no limit on the frequency of breeding, and the breeding frequency is actually one of the key problems in puppy mills, because mother dogs are just bred repeatedly throughout their entire lives with no rest. So last year, at the end of 2015, HSUS, along with the ASPCA, filed a rulemaking petition with the USDA to upgrade the regulations and in our view, bring them into compliance with the Animal Welfare Act. Our petition focused on 2 key areas. One is the physical requirements of the facility, and the other is health and welfare requirements. So I'm just going to go through briefly some of our key requests in that petition. And our petition provides all kinds of background and current research, along with the agency's own experience through inspection reports and regulation that demonstrate that these standards need to be updated. So one of the most important things that we asked for was that the agency prohibit wire flooring in commercial breeding facilities. The existing regulation was promulgated in the late 90s, and at the time the agency said that it found no evidence that wire mesh flooring, as long as it was each strand was greater than 1/8 of an inch in diameter, or if it was less than that, that the strands were coated with plastic or fiberglass. The agency found that this was adequate to provide for the welfare of the dogs, and they said there was no evidence to the contrary. And in fact, at the time, the agency also removed a provision that had previously been in place from 1991 regulations that required a solid resting board or platform in the dogs' cages if the flooring was made of wire mesh. And they removed that in 1998, largely because the industry had pushed back against that, saying that it was inconvenient, unnecessary, and created an unhealthy, unsanitary situation because it was difficult to clean the resting boards. So unfortunately, the regulation as it currently stands has no requirement for a solid resting area at all. And inspection reports make very clear that, along with current research, that wire mesh flooring, even if it's completely compliant with the current regulations, is not adequate to protect the welfare of the dogs. They get a lot of foot and joint injuries, difficulty balancing, sometimes difficulty regulating body temperature. So we've asked that wire flooring be eliminated. We've also asked that the cage space requirements be doubled in size from what they currently are. The current regulation, which was passed, I think in the early 90s, 1991, requires only that the cage be 6 inches longer than the biggest dog in the cage on all sides and 6 inches higher than the dog's height in a standing position. And it's our position that this is inadequate for dogs to protect their psychological and physical needs. Anybody who has a dog knows that that's probably inadequate, especially if they're kept there day in and day out for their entire lives. And interestingly, one of the bases for the agency's rationale behind why this space was adequate at the time was because they said there was also, as a result of the 1985 amendments to the Animal Welfare Act, there was now an exercise requirement. Dogs were getting exercise, so that was even more reason why the space requirements for the primary enclosures was adequate. But as Kathy alluded to, and as I'll talk about in a second, the exercise requirements are totally inadequate, so that does not counterbalance the need for increased primary enclosure space. We've also asked that the agency eliminate the practice of cage stacking. The agency has never addressed this, even though it is a key component of puppy mills. And the reason that a lot of breeders do this is because it allows them to maximize the use of their space. But unfortunately, it creates a situation where there's overcrowding in that limited space. The air quality is extremely poor. Disease transmission is elevated because of the close quarters, and it makes access to the dogs more difficult. In extreme cases, there's also situations where the waste from the upper deck can fall onto the dogs in the lower cages. One of the other key components of our petition is a request for unfettered access to an exercise run that's at least double the size and with solid flooring, ideally outside, double the size of the primary enclosure. As Kathy discussed, the 1985 amendments to the Animal Welfare Act did mandate an exercise requirement, and it delegated to the agency the obligation to promulgate regulations. In one of their proposed regulations, I think in 1989, the agency did actually propose a minimum exercise requirement of 30 minutes a day for dogs. That was ultimately overcome in the final regulations in response to industry pushback, and not wanting to have to comply with a minimum requirement. Instead, ultimately, the agency passed regulations which allow for the breeder, in conjunction with their veterinarian, to develop a plan. And again, as Kathy discussed with regard to the research dogs, this allows for altogether too much discretion to the breeder and their veterinarian to come up with a plan that there are no strict standards about. So the regulations require that the plan allow for regular opportunity for exercise, but there's no definition of regular, and there's really a lot of discretion. So that's one of the key problems. The other one is the complete inability to enforce. So even if an exercise plan says dogs have to be allowed, out once a day, there's really no way for the inspectors to know whether that's happening or not. So that's one of the key reasons why we think there should be an engineering standard, in other words, unfettered access from the cage to an exercise run. Oh, and one more thing with regard to the exercise regulations as they currently stand. There is a complete waiver of minimum exercise requirements if dogs are housed in groups. As long as each dog has the minimum mandated space, there's no exercise requirement at all. So they could literally, it's okay for the dogs to spend their entire lives in a cage. The two other big ticket items that we asked for are a restriction on frequency of breeding, which the agency has never addressed. And again, as I mentioned, this is very problematic for breeding dogs who start being bred from when they're very young, and they're bred until they're no longer able to breed, just litter after litter after litter with no rest. So there's differing opinions among veterinarians and experts as to what is the appropriate parameters for that. But there's pretty widespread consensus that there should be some restrictions on the frequency of breeding. Our petition requests no more than 2 litters in an 18-month period. For veterinary care, the current regulations require that there be a written veterinary plan that the breeder come up with in conjunction with their veterinarian, and do require adequate veterinary care. However, there's no specific requirements as to what that means. So we think there should be a requirement for an annual hands-on veterinary exam, which there currently is no requirement for. And we think that there should also be mandated screening of breeding dogs on at least an annual basis to screen them for hereditary defects, first of all, before they're cleared for breeding, and second of all, just to make sure that their body is in a reasonable condition to breed. And we also asked for certain preventive care, such as vaccinations and the like. And we also had a few other miscellaneous items that we asked for, which are also very important, but the ones I already discussed are kind of our key asks. I'm happy to discuss any more of these if people are interested. Thank you.
There's pointer.
So thank you, everybody. Good morning. My name is Naomi Rose, and this is my colleague, Georgia Hancock, and we're going to talk about captive marine mammals, so we're going to change up the pace a little bit here with regard to the Animal Welfare Act. So these are the species that are covered under the Animal Welfare Act. Obviously, whales and dolphins, seals and sea lions, those are the ones you might expect, but also polar bears, sea otters, and manatees. Polar bears, of course, are just bears, and sea otters are very closely related to river otters and other otters, and weasels, but they are considered marine mammals because ecologically they are tied to the marine environment. They cannot leave the marine environment and survive. And so under the Marine Mammal Protection Act, they are considered marine mammals, and therefore the Animal Welfare Act also agrees that they are marine mammals. Now, the one good thing we can say about the Animal Welfare Act when it comes to marine mammals is that they have their own subpart, their own section. There are 18 sections that are specific to marine mammals. So the Act does recognize that they have special needs. That's about the extent of the good stuff I'm going to tell you about the Act when it comes to these species. These 18 sections were first promulgated back in the 70s, and there was a cooperative agreement with the National Marine Fisheries Service under the Marine Mammal Protection Act to co-govern the care and handling of marine mammals in captivity. 20 years ago, the Animal and Plant Health Inspection Service actually recognized that those standards were out of date. In fact, they convened a negotiated rulemaking panel, which I was a member of, so I've been around for a while. And this negotiated rulemaking panel was probably one of the first and only times that APHIS tried this method, as far as I'm aware. And it was an effort to get all of the controversy and all of the adversarial positions sort of hashed out in advance of doing the rulemaking so that, you know, theoretically, the rulemaking would go ahead smoothly with minimal controversy and then be finalized in an expeditious manner. So they got together they convened stakeholders from the zoo and aquarium community, from the animal NGOs, again, that's where I came in, and also academics, including a neutral arbitrator who was meant to sort of try to control the animus at the table, and that was Dr. Joseph Gerasi, who had the confidence and trust of both sides of this debate. And we met several times over the course of these 2 years, and it was a very interesting process, as you might imagine. And believe it or not, we came to consensus on 13 of 18 provisions. Now, that sounds really good, but these were the low-hanging fruit, the easy ones. Things like record keeping, staffing requirements, and so on. There were 5 sections we could not come to consensus on. 4 of them were the conditions under which these animals are held, the meat of the matter, as it were, no offense. And so this was where we could not come to consensus. So we're talking about space requirements, indoor and outdoor facilities, which include temperature, salinity, things like that, and then also water quality, what level the bacterial levels and the chemical levels in the water could be, how clear the water needed to be, etc. We could not come to consensus on those. And then there was the 5th section, which I will turn over to Georgia to discuss.
And excuse me, I conveniently started to lose my voice last night, so just bear with me. So the 5th section, section 3.111, governing the swim with dolphin programs, was not part of the NEGREG process. It underwent its own traditional rulemaking, which began in 1994 after APHIS assumed full jurisdiction over swim with programs. It previously shared that jurisdiction with NOAA because NOAA administers the Marine Mammal Protection Act. But when the MMPA was reauthorized in 1994, that removed NOAA's jurisdiction over captive marine mammals and turned it over to APHIS. In April 1999, APHIS published the final rule for the swim with dolphin programs. While the NGO community would have preferred that swim with programs be banned altogether, if swim with was to be allowed, the regs weren't actually that bad. They were quite strict in that they required refuges or freely accessible places where the animals could go if they didn't feel like interacting with people. They were also strict with regard to medical treatment required for the animals because they were exposed to additional risks from being around people all of the time. However, the swim with rule was short-lived. Within 6 months, APHIS suspended enforcement when a few facilities that had only wading programs, meaning that participants were only in the water up to about their thighs, they complained that it was unfair that they were included in the rule. So instead of suspending the rule just for the wading programs, APHIS suspended it for everyone. That was in 1999, and we still don't have specific swim with dolphin regulations. The number of swim with programs has probably increased 3 to 5-fold since then, and yet, except for that brief 6-month window in 1999, these programs have only been covered by the general regs. Please keep in mind these animals are exposed to a constant stream of people, and they're under increased stress because of that, and yet they receive no special regulatory treatment. So, as Dr. Rose mentioned, 1996 was when the parties to the negotiated rulemaking came to consensus, and yet the agency didn't publish the regs for those consensus sections until 2001. Even the industry was getting anxious for the agency to publish the regs because they wanted to know where they stood. If they were going to construct new facilities, for example, they wanted to know how big they needed to be. So they were just as annoyed as the NGO community by the agency's 5-year delay. For the remaining 5 sections on which the parties did not reach consensus, APHIS pursued a traditional rulemaking. It published an advance notice of proposed rulemaking in 2002, 1 year after the consensus regs were finalized. So insert a 14-year time gap here. That's right, 14 years after the ANPR, APHIS finally issued a proposed rule on the 5 sections for which consensus was not reached. That was in February of this year. In essence, we waited for virtually nothing, as one of the most important sections, that on space requirements, remained unchanged. Dr. Rose will explain further.
So, in the past 32 years, since 1984, when the space requirements were last updated, there's been an enormous amount of field science on these species. And I can tell you, because that's when I started my career as a marine mammal scientist, back in 1984, there was a lot of things we still didn't know about these animals in the wild. Tags at that time for these animals were the size of toasters, and it was really very difficult to put them on a lot of these animals. In the last 15 years alone, we have now seen an enormous amount of progress on learning how these animals actually live their lives in the wild. Tags are now the size of $50, and they can go to great depths with the animals. So we know how deep they dive. We know how far they travel in a 24-hour period. We know what their home range sizes are. These are things we didn't know 32 years ago. These are things we didn't know 15 years ago. So for APHIS to say in their proposed rule, we are unaware of any science. We are unaware of any science that justifies changing the current standards for space, which are minimum standards from 32 years ago, is simply inexplicable, right? Large animals, small enclosures. But even more important than that, wide-ranging animals, small enclosures. There's been a lot of metadata analyzed by Clubb and Mason, for example. Some of you may be familiar with that paper, where they look at polar bears, big cats, other animals that are wide-ranging in nature. Okay, so these are wide-ranging animals. This is a typical dive of an orca. He'll make that dive multiple times in a day. From left to right is about 5 minutes. Right? This is a 5-minute dive. He'll make this dive several times a day. This is not unusual. He goes down to 525 feet. And he does something down there. He's not just sitting down there. He's foraging. He's doing something. And he comes back up. This little blue box in the middle of the graph, up at the top here, is Shamu Stadium at SeaWorld. In San Diego, 11 animals live in that space. In San Antonio, 6. In Orlando, 7. All right? That's as big as it is. That's the largest enclosure we have in the United States, and it is far in excess of the minimum standards that APHIS establishes, far in excess of what the minimum standards are. Yet this is a typical dive for an orca. There has to be an agreement that there's something wrong with this. Common sense says when a typical tank is only 1/10,000th of 1% the size of natural home range, you're not providing adequately for that animal. This is, again, more new technology. That graph of the dive comes from this new tagging technology I mentioned. Here's some more new technology. This is from drones. Right? We now get a bird's eye view of the way these animals live in the wild. So this is a group of belugas. Thousands of animals can congregate in the same space. This is a group of bottlenose dolphins. They live in fission fusion societies, get together, break apart, get together, break apart with up to 100 to 120 animals. Think of it as a village. This is a family of orcas. This is a mother and all of her children and all of her children's children. They are extremely strongly bonded with family. And this is a bunch of Pacific white-sided dolphins. Again, thousands of them can congregate out in the open ocean. When they are put into captivity, they do not even need to be allowed to live with conspecifics, the same species. It is legal under the regulations for these animals to be held with compatible species. So they do not even have to be held with the same species. And these are animals that live like this. Again, common sense says there has to be something wrong with that. And now I'm going to turn it back over to Georgia to talk about enforcement.
We can, in various inspection reports, see that the minimum enforcement APHIS does provide over marine mammal facilities tends to be limited to cosmetic citations rather than major substantive violations. For example, in 2015, an inspection report cited the Mirage Hotel and Casino in Las Vegas, which displays dolphins, for an unsanitary food prep kitchen. These citations are essentially fix-it tickets, typically with 30 days to correct. However, according to the group Mojave Dolphins, despite the order for the Mirage to address the sanitation violation by mid-July of 2015, there had been no follow-up from USDA as of late September of that year. A 2012 inspection called out SeaWorld of Florida for various infractions that you can see here. APHIS told SeaWorld to put a protocol in place to prevent these sorts of things. But how alarming is it that in this facility's 30-year history, such protocols were not already in place? This image is of Lolita, a killer whale who is famous for her tiny tank, which is not in compliance with the AWA. Lolita, who has been in this small tank since 1970, is the prime example of why the AWA is not working for captive marine mammals. In any given tank, the existing APHIS regs require a minimum horizontal dimension of only 48 feet for orcas, which is just over twice Lolita's length. As you can see in this picture, the work island, right there, which goes all the way to the floor of the tank, creates an obstruction. APHIS claims this is a partial obstruction and therefore it's okay. The agency claims the minimum horizontal dimension requirement is met by virtue of the fact that when these gates are open, right there and right there, Lolita can swim the circumference of the tank. However, based purely on geometry, a circumference is not a minimum horizontal dimension. It's only 35 feet from the work island to the top end of the pool, there, which is clearly less than 48 feet. This letter excerpt from APHIS shows that it is claiming that there are two minimum horizontal dimensions, but by definition, you can't have two minimums because a minimum is a minimum. Lolita's situation has been litigated by groups such as PETA and ALDF, unfortunately without much success to date. In closing, Lolita is the poster child for everything that is wrong with the AWA's treatment of captive marine mammals. The law that is supposed to ensure the humane care and treatment of marine mammals in captivity has singularly failed to do so. As Dr. Rose has attested, marine mammal science has progressed tremendously in recent years, but this science was ignored by the agency in its proposed rule. And if you'd like to see our comments, feel free to get a hold of us. Thank you.
Good morning, everyone. My name is Anna Frostig, and I'm the Senior Attorney for Wildlife and Animal Research Issues with the Humane Society of the United States. It's a pleasure to be here with so many esteemed colleagues, and wonderful to see the breadth of interest in these issues that affect countless animals, including several critically endangered species. I'm going to talk today about the commercial use of exotic animals, and infant exotic animals in particular. And these are animals that are maintained at licensed exhibitors that have to comply with the Animal Welfare Act. And in particular, I'm going to talk about the Animal Welfare Act's animal handling regulations. So this issue addresses both animal welfare, public safety, and conservation concerns. I'm going to give a little factual background to the scenario and then talk about some of the things that we're doing to try to address these problems. Around the country, we have about 80 facilities that we've identified, primarily what we call roadside zoos, pseudo-sanctuaries. These are not your major accredited institutions, for example, like the Detroit Zoo, where we have representation from and has worked with us on this project. These facilities, just like puppy mills, are breeding animals specifically for commercial use, and primarily the use that we're going to talk about is public contact, direct physical interaction between paying members of the public and often infant animals. So what we have here is of particular concern with big cats, bears, and non-human primates. There are certainly other animals that are used in this industry, but these three taxa are the ones that we focus on, in particular because of their popularity for this purpose and also because of the demonstrated negative impacts that this activity has on these animals' lives. So we have hundreds of tigers, lions, bears, chimpanzees, monkeys, etc., that are used by these facilities every day. And I think of this problem kind of in the life cycle of a particular animal. So as soon as the animal is born, it's prematurely separated from its mom to be hand-reared by the exhibitor, specifically in an attempt to tame this wild animal to be compliant with direct handling by the public. So here you have an infant chimpanzee being held by somebody who is clearly not its mother, a human infant interacting with an infant bear, neonatal tigers being held by another member of the public. And it's very well demonstrated, especially in the primate universe, and interestingly, much of this research came out of the use of primates in research laboratories. Overwhelmingly well established that there are negative long-term behavioral and physiological impacts of severing the mother-infant bond in mammalian species. Soon after these infants are pulled away from their moms, they are put into use, and members of the public, from fees ranging from $50 to $500, depending on the scenario, pay to interact with these babies. We have a facility in Florida that is allowing people to swim with baby tigers. As long as there is a line of people ready to swim, those tigers are paddling for their lives. Gibbons being brought to parties is critically endangered species. The picture at the top, I don't know what happened there, but there is, I can see it's a little bit dark, but there is a baby tiger behind there, which you can barely see. This is a tiger that was held at a facility in Oklahoma where HSUS did an undercover investigation. This individual cub was driven from a breeder in South Carolina to Oklahoma, and immediately upon getting out of the car was handled by 27 people, even though she was only 3 weeks old and was diagnosed with ringworm at the time. So part of the problem with this setup is that the severing of the mother-infant bond, especially with these infants, results in an inadequate diet for these babies. Clearly, mammalian species, there's a very wide range of the length of time that these individuals in the wild remain with their moms. On the far end of the spectrum, we have orangs that are with their moms for up to 8 years, usually nursing for at least 5 years. Even a tiger usually nurses for somewhere between 3 to 6 months. So when you pull an infant away at the minutes after birth or days or weeks after birth, you're depriving them of the traditional diet that that animal is accustomed to. And it's being replaced by often public feeding, which has a host of issues in terms of ensuring adequate nutrition, style of feeding, and making sure that they are getting the appropriate amount of food. So in particular, a problem that we have there, that we have seen there, is the dependency on bottle feeding. So up in that left corner, you see this baby tiger being fed a bottle. Routinely, when we have done investigations, and we've done 3 undercover investigations, HSUS has, and PETA and ALDF have certainly looked into this issue more broadly as well, that you have cats that are being made to be dependent on bottles for far longer than they would be in comparison to their growth in the wild. So you have animals that are not being given meat replacements. Instead, they're being dependent on bottles so that when they are used for photo opportunities and interactive experiences with the public, they are distracted. They're less likely, in theory, to get playful or bite and scratch an individual. And this type of feeding has clearly resulted in an inadequate diet for these baby animals. We've also seen in our undercover investigations a significant amount of abusive, quote, training or discipline. So in the bottom right-hand corner there, you see an individual named Bill Meadows who runs a facility, Tiger Safari, in Oklahoma, the same facility I referenced a minute ago, demonstrating what he called the, quote, sleeper hold for a neonatal cub. Unclear exactly what is going on there, but effectively was a technique that this individual uses to kind of calm the baby, and significant concerns of repeatedly turning these infants upside down and on their backs effectively. A lot of punching and slapping, dragging of animals. These are obviously very rambunctious and powerful animals that are through physical means attempted to be tamed so that they can interact safely with members of the public. So in addition to some of those animal welfare concerns, we also have public safety concerns affiliated with this practice. Certainly, infants are highly desirable in this industry, but the length of time that an animal can be used is pushed to the limit so that the maximum profit can be derived from each individual animal. And we certainly have seen instances routinely where very large big cats, although perhaps not fully grown, are posing next to individuals to take photos. This photo on the bottom right here is one of my favorites, fully grown black bear with a little piece of plexiglass in between this mother who is questionably holding her toddler next to this bear. Teenage orang giving a hug to a teenage boy. These are scenarios in all of those photos that very clearly represent a posed risk to the bodily, severe bodily injury for the members of the public that are interacting with these animals. In addition, there's a significant concern about zoonotic disease transfer. So in the top left corner there, you see an adorable baby macaque monkey that is dressed in a dress and interacting with this Girl Scout troop or some other group of schoolgirls. And macaque monkeys routinely carry herpes B virus, which is known to be fatal to humans. And so you have direct interaction between animals and members of the public where there's a very clear risk to the health of the individual person as well as to the animal. And that can go both ways. For example, big cats are very susceptible in captivity to canine distemper. It's entirely possible that an individual person who's interacting with a big cat could bring the canine distemper virus from a family dog to the facility and expose that animal to the disease. So significant concern about disease transfer. In addition, once these animals get too big and are no longer profitable for the public contact industry, they put a significant burden on the animal protection community, who often is called in to rescue these animals and provide them with actually appropriate enclosures. And you also see these animals being sold into the exotic pet trade. There's an ad right there. So often there's so many tigers in particular, for example, that they aren't even sold. They are just given away free to a good home. And this is an ad from something called the Animal Finder's Guide, which routinely advertises the sale and otherwise other trade in exotic animals. So this activity is regulated under the Animal Welfare Act, despite all of these copious examples of the negative impacts that are happening. These are the particular provisions that are in play. They come, again, from the statutory authority that has already been discussed for the agency to develop regulations pertaining to the humane handling of animals. There's a generic animal handling regulation, 9 CFR 2.131, where much of this language comes from, and then there are a few primate-specific examples that are the other sites there, and the language in the bottom right-hand corner. So these are stereotypical performance standards. Effectively, we have concepts here like sufficient distance and barriers, no unnecessary discomfort, no rough or excessive handling. Dangerous animals have to be under the, quote, direct control of a knowledgeable handler. And for primates, it's just explicitly there that if the primate is trained, it's okay to have public contact with that primate. So these regulations have resulted in an industry that is booming. And in order to address that issue, the Humane Society of the United States, World Wildlife Fund, Detroit Zoo, Fund for Animals, International Fund for Animal Welfare, Born Free USA, Global Federation of Animal Sanctuaries, and Big Cat Rescue all together petitioned the U.S. Department of Agriculture for an explicit regulation that prohibits direct contact and unsafe close contact between members of the public and big cats, bears, and non-human primates. That petition was submitted in 2012. In 2013, the agency opened a public comment period on it. And thankfully, in 2016, we actually saw some action, which I think is maybe the first time that's been said today. Hopefully, we'll hear some more about that. A piece of this has now been addressed, which is that in 2016, the department, instead of changing its regulations, decided that their authority from these existing regulations is broad enough that they can issue a legal interpretation that allowing members of the public to have direct contact with neonatal cats under 4 weeks of age is already prohibited under these existing regulations and also the veterinary care regulations. And so we saw that, quote, technical note issued in April of this year. And then this summer, the agency opened another comment period on the issue, and we're hoping to see additional action. I will note quickly, because I think it's a nice transition to the next panel, though I know we have a significant question and answer period here, that in addition to these public safety and animal welfare concerns, there are enormous conservation concerns with this industry. So we have breeding of critically endangered species without regard to genetic integrity, hybridization, inappropriate social grouping. And there is a body of literature that is growing that the use of animals in these types of commercial entertainment, in this commercial entertainment industry, has negative impacts on wild populations, both in terms of people's perception of whether the species is endangered, and therefore their likelihood to contribute to conservation efforts to save those species, an increase in the demand for these species in the exotic pet trade, and an overall misunderstanding of the animal's biology and need for help. And so this is an enormous concern. With tigers in particular, the WWF has also raised the concern that we have more tigers in the US than we do left in the wild. There's about 3,200 tigers left in the wild, and we have approximately 5,000 to 7,000 tigers in the US, and 99% of those, if not more, are living in backyards, basements, and unaccredited facilities. There's an enormous concern that parts from those animals are worth more money dead than they are alive, and parts could be diverted into international trafficking. So huge conservation concerns in addition to the animal welfare and public safety concerns, and we've seen some action, but we're certainly hoping to see more action. Thank you very much.
Thank you for those great presentations. So, timekeeper, can you be a timekeeper for me as well for the Q&A period? Thank you. And all of you, I'm going to start us off with some questions, but please do, if you have questions, write them on the cards and they'll be gathered and brought up to me. So I think I'd like to start us off asking about the USDA has repeatedly in recent years indicated a preference for what it refers to as non-regulatory approaches and for using policy guidance along the lines of the recent development that Anna mentioned. And I think under the Trump agenda that you mentioned, Kathy, we're probably going to see more of that. And I'm wondering if all of the panelists could respond to what they think the implications of that are for your efforts and how you're going to grapple with that. And whoever wants to get us started can jump in.
I'll jump in quickly just because I was referencing this technical note. I mean, I think the petitioners with this public contact issue have clearly shown a preference that we have a clear, bright line regulatory prohibition, no public contact, so that there is no confusion between various inspectors and there's consistency across the board with what is allowed and what is not. That said, we were very pleased to see the agency take the step of interpreting its existing regulations, which are extremely broad. And I think that there's more room for us to advance the ball on this particular issue with similar other interpretations that go beyond just cats under 4 weeks of age. I think we could get much of what we are looking for through that type of technical note, at least on paper. I think enforcement-wise, it remains to be seen whether the industry will respond the same to those types of interpretations as a change in regulation.
And you don't all have to answer the question, but I wanted to give everyone an opportunity if they want
I
to.
think your particular issue is you're able to take advantage of the aspect that there's a threat to human health, and I think that will be viewed very differently than some of the other issues of just trying to protect animals. And I do think we may have a tough road ahead and may look to, as I was saying, diminished number of inspectors in the field. So looking at how do we try to get the most out of those inspectors, loss of transparency, which already is happening, but I think may well continue, and trying to hang on and rally the public. And of course, we're still waiting to hear who we'll have as a Secretary of Agriculture, and that will be significant.
Given that it took 20 years for the proposed rule to be published that addressed the significant aspects of the regulations, I'm a little concerned that it'll take forever for a final rule, and especially in the current political climate. So I do think there's a lot of change happening just through the public will shifting, because of the blackfish effect and these sorts of things. And so I'm hopeful that the lack of action on the part of the agency will be less critical. But I don't really have a lot of high hopes for this rule moving forward expeditiously, because I've grown old waiting for the proposal, let alone the final.
I would say that while there may be things that we could work with the agency on to improve short of regulations, I would say that we're probably likely to continue to focus on consumer awareness and trying to make the public aware that USDA regulation is not equivalent to a humane facility, and also working on increased licensing of individuals, of breeders who aren't even licensed, so falling even below these minimum standards.
And actually, if I could say one other thing, which I think a recent decision by, I believe it was TripAdvisor, to not list certain facilities. So we, I think, need to look to new and different ways to have an impact that don't count on the government.
That's a great transition. So I was going to, again, open up to the panel what your thoughts are on corporate strategies and voluntary changes made by corporations, like the TripAdvisor development, like SeaWorld agreeing to phase out orcas, the National Aquarium agreeing to send dolphins to a seaside sanctuary. Do you think that's somewhere we should be focusing our efforts?
Well, certainly for captive marine mammals, that's where all the focus is right now. I did put a great deal of effort into my comments for the proposed rule, which again we have available on our website, and so please let us know if you'd like to see a copy of those. But I didn't really see that as where I needed to put most of my energy. Where our energy is focused right now in the community is corporate change, corporate pressure through other corporations like partnerships, severing partnerships between, say, Southwest Airlines and SeaWorld or something like that. And then, for example, we're working right now in Arizona where there's a new facility, and we're working purely in the public, arena, campaigning, public awareness raising, and we're not even thinking at the moment of going to the Arizona state government, for example, and trying to get stronger regulations under the state government. That, in our opinion, is not a fruitful avenue at the moment, and we're focusing on public awareness. And I think that is true for any charismatic, megafauna. So big cats, primates, I don't know a lot about that, but I would argue that that's a fruitful way forward.
I agree that there's definitely potential there, and the TripAdvisor decision is certainly enheartening. Potentially there are other companies that operate in the same sphere as TripAdvisor that don't themselves own animals, for example, like a Groupon or another facility that's helping to advertise these types of activities. But unlike in the marine mammal context with tigers and other big cats, bears, primates, et cetera, the number of players that we have is very diffuse. And so we don't have the advantage of having one corporation that has sole control over the vast majority of animals that we're concerned about. And so it's been a little bit difficult to think of a corporate strategy to get a big bang for your buck effectively.
We definitely work a lot with the industry to try and come to some kind of agreement on standards. Over the last few years, there's been a lot of discussion with industry, pet industry associations along those lines. And part of the reason they're coming to the table more than they have in the past is because there's a lot of local activity with ordinances being passed around the country related to the curtailing of retail sales of commercially bred dogs. So I think that, more than anything that's happening on the USDA level, is causing the industry to pay a little bit more attention to how they might change their practices. So I think we'll continue to work along those lines.
So yeah, I want to ask more about those local legislative efforts. So one question that we got from the attendees is, to what extent are the individual states, quote unquote, making up the difference? And I would add to that, localities. I think we're seeing a lot of movement on some of these issues, and I'm wondering what role you all see state and local legislation. And then for a lot of the things that you're working on, there's also federal legislation pending that might address some of these issues. So if there is, can you speak to what your hopes are for that?
One of the entertaining aspects of this for me is that in 1994, prior to that, the jurisdiction over captive marine mammals was shared by the National Marine Fisheries Service and the Department of Commerce and USDA, APHIS. So they had a memorandum of agreement, and they shared jurisdiction. And then the industry, primarily the Alliance of Marine Mammal Parks and Aquariums, lobbied very heavily in 1994 to change the Marine Mammal Protection Act during its reauthorization to remove the jurisdiction of the Marine Mammal Protection Act and NMFS, National Marine Fisheries Service, from the captive marine mammal arena. And it was because NMFS has 80 to 100 marine mammal experts and used to weigh in heavily on the conditions that these facilities had to meet to have certain animals in their care. And APHIS has 2 or 3 marine mammal experts, and very rarely established any kind of special conditions. In fact, of course, they can't under the licensing regime. So it was NOAA and NMFS that put in those special conditions, and the industry didn't like it. So they removed that jurisdiction successfully in '94. Well, that now means that the Marine Mammal Protection Act, which has jurisdiction over all federal marine mammal issues, they preempt all state law on marine mammal issues. Because they are no longer responsible for captive marine mammals, that preemption is gone. The industry is actually very upset about that now that it's come back to bite them in the posterior. And they are, in fact, arguing in court, which was the entertaining part of it for me, that no, the Marine Mammal Protection Act preempts state law. And we were very happy to be able to show them that they changed the law in '94, so that is no longer true. And sorry you didn't recognize the future and realize you were sabotaging yourself, but too bad. So we have, in fact, passed a law now in California, which prohibits the breeding of captive orcas and the import and export out of the state. And so eventually there will be no orcas left in captivity in California, as those 11 orcas that are currently at SeaWorld live and grow old and die. And they actually argue that that shouldn't happen. You can't preempt the MMPA. Well, the MMPA has no authority over captive marine mammals. You did that. Live with it. So yeah, that's that. So now we're going to go to Florida. We're going to go to Texas, and then we're going to go beyond that to states that have belugas and bottlenose dolphins. It'll take a while, but I think we can do it. We also are looking at a federal bill, but I'm not very hopeful about that anymore.
I think there's enormous opportunity in the legislative realm on the public contact issue. I mean, certainly states have jurisdiction over the mere possession of these animals, and so we do already have several states that have prohibitions on public contact in their regulations. That could certainly be expanded. There's also a federal bill that's pending this Congress and likely to be introduced in the next Congress, the Big Cat Public Safety Act, that would prohibit on the federal level the possession of big cats. There's an exemption for USDA licensed facilities, but that exemption only applies if the facility does not engage in public contact. So we've worked in the public contact prohibition into that federal legislation as well.
There isn't much hope, I think, on the state level for addressing research laboratories. Certainly the suppliers, those breeders and dealers, there is the potential there, and some are covered under state law. And of course, many research facilities are exempt under state law from anti-cruelty statutes.
I would say in the puppy mill context, HSUS, is, along with other animal advocates, is always working on state levels to try and improve the standards of care required in breeding facilities. Some states have more rigid requirements than the AWA regulations, not significantly so, but somewhat more so, and working in states like North Carolina, where there's a lot of puppy mills, but no standards of care, to try and improve upon that. I'm not sure there's an extraordinary amount of hope, but there's definitely room to grow there.
Thanks. So, Kim, a lot of questions have come in for you, actually. So I'm going to ask one that is targeted specifically to you, but I think it gets at a bigger question for the panel, which goes to enforcement. So, Georgia, you mentioned that inspectors tend to, in your view, focus on cosmetic issues, and I think we're going to hear a lot more over the weekend about enforcement issues with the Animal Welfare Act. There's been repeated criticism from the Office of Inspector General. And so my bigger question for the panel is, given these enforcement issues, even if we were successful in improving the standards, how far would that get us? And Kim, the specific question for you is, when a USDA inspector finds a dog who is obviously exhibiting a need for veterinary care, what is the USDA's practice in responding to such an animal and its owner/exhibitor? On extremely rare occasions, the dog might be confiscated, but almost never. More typically, the agency will impose a deadline for ensuring that that animal gets veterinary care, and then will follow up soon thereafter to see that that was accomplished. And more often than not, the breeder will do what needs to be done just to get through that violation, and then will continue to be licensed. That's the short answer, I think. But very, very rarely, and Delcy knows more about this than I do, but will a dog actually be confiscated, even though the agency does have authority to do that?
Yeah, and I think on the enforcement issue more broadly, I mean, certainly in the context of the issue that I was discussing, we are asking for a strict prohibition on a certain type of activity. And so it's kind of you're in or you're out in terms of compliance. And I was very heartened to see that after this technical note came out in April of this year, that one of the facilities that we had been tracking for years that was engaged in public contact with tigers was announced on its own volition that it would no longer be engaged in that practice, even though the technical note only prohibited public contact with cubs under the age of 4 weeks. They acknowledged that if they couldn't allow members of the public to have contact with those neonatal cubs, that those cubs would not be compliant with contact at an older age, and so they got out of the game.
Thanks.
And regarding enforcement with laboratories, certainly we were very pleased with the fine in the settlement with Santa Cruz Biotechnology and the multi-million-dollar fine. And certainly we hope that that was the dawning of a new age. That remains to be seen, and certainly early indicators are it's back to business as usual. And the problem really begins with an inspection force that oftentimes may be fairly good, but if they're repeatedly going back and writing up problems and not seeing any action taken on them, that is going to have an effect on morale. And there needs to be the prompter action versus a tremendous length of time until something is done. And of course, typically the fines don't serve as any kind of disincentive. That's just the cost of doing business.
For marine mammals, there aren't a lot of bright lines. Most of them are performance-based standards, so enforcement is difficult. But for example, with the case of Lolita, 35 feet is not 48 feet. That's a pretty bright line. And they still came up with, it's actually 60 feet because she can somehow swim through a solid concrete wall. And 80 feet is the second minimum horizontal dimension, which is just, they actually wrote that down. I don't know what to do with that. When the agency's that internally illogical, publicly illogical, it leaves me at something of a loss.
I also think, while APHIS does have a lot of inspectors, as Naomi mentioned, they have generally, little expertise in marine mammals specifically. And so, they may go and not necessarily, catch everything that maybe they should. And, which is why it's important that you have, for example, with SeaWorld, members of the public and experts pointing out things like dental issues that the whales are experiencing from chewing on parts of their tank. It's just it's crazy. So thank you.
I want to get back to this issue that Kathy opened us up with on performance versus engineering standards, and I think Lolita is a good example of that. That actually is an engineering standard, and we still have problems. And Kim, you talked about the space requirements for dogs, and that is an engineering standard. So, and I think one of the challenges with engineering standards is that they do need to be updated as we learn more about what animals need, and as we've seen, the pace of regulations is not particularly rapid. And so how do we resolve that tension? In that sense, is that an argument in support of performance standards and that it allows things to evolve over time as the science evolves?
I certainly think that in certain areas it is difficult to come up with an engineering standard. The primate psychological well-being concept that Kathy raised earlier is another performance standard. We have to have a plan that's sufficient to promote. I mean, it's about as vague of regulatory language as you can get, but it is an enormous task to come up with an engineering standard for what constitutes a sufficient environment for every single captive primate. I mean, the amount of differences in needs of different species, the different types of environments that they're in. You have one regulation that's applying to laboratories as well as exhibitors. It is a very loaded concept. And so in terms of coming up with one regulation that would have prescribed standards for every single concept, it's a difficult task, and I understand how the agency could deem a performance standard to be a more efficient way of regulating that field. Not that I endorse that, concept broadly, but I do think that there are certain areas where performance standards, might be a necessary evil.
To a certain extent, I feel like the agency has pretty much just washed its hands of, the problem by saying, here's our proposed rule. We're not really changing anything from 35 years ago in the case of marine mammals. So I don't know what the solution is. We did try to come up with one in our comments. So certainly, again, I urge people to look at those if they're interested in a longer answer to this question. We tried to come up with some practical, doable, affordable options for what the regulations could be that would improve the welfare of these animals. But I don't really know what the long-term solution is to performance versus engineering standards, because I recognize what Anna mentioned. It is a problem. That is almost an insurmountable problem. There are so many animals and different species to consider. But I do know that the status quo is just not doing it for these animals, so I just don't know where the reasonable medium is.
I mean, I guess I would just say that at least in the case where there are already existing engineering standards, such as with dog cage space, where those are clearly inadequate, I don't think we can not push for those to be upgraded and to have at least a minimum requirement that, you know, is arguably humane. And I can understand, you know, the need for some flexibility with different breeds, different species, but I think the key problem is accountability and enforcement. And, you know, if there were some way of holding the industry accountable to the performance standards on a reasonable basis, I can certainly understand why some flexibility is prudent.
And I do think we need certain engineering standards now based on the science that's been developed on primates, for example. I mean, there's no reason not to require group housing or social housing. And if that can't be done, there ought to be very heavy a burden to explain why. And I don't know that we have any proof about performance standards being any better enforced than engineering standards. We're just in the dark even about what those are, let alone ability to comply with them. But I would agree, certainly, the size of enclosures needs to be increased and not left barren, but rather it's what you then do with the space.
One additional comment on the primate issue is that, you know, we do have, at least for certain species, very clearly defined standards. I mean, the National Institutes of Health has established very clear standards for what is a, quote, ethologically appropriate environment for chimpanzees. And those standards far exceed now what the USDA is requiring under the Animal Welfare Act. So you have the agency that's assigned to promoting, you know, animal research and biomedical research in particular, recognizing that chimpanzees have needs that are not met by the, you know, bare minimum of what's currently in the Animal Welfare Act.
And that is true, too, for marine mammals, because there are two professional associations that are relevant here. One is the AZA, and then the other is the Alliance of Marine Mammal Parks and Aquariums. And both of them have standards for accreditation, and both of those sets of standards are in excess of the minimum standards. And understanding that, you know, minimum standards are minimum. They can't, you know, they're not maximum or even medium. They're median. They're minimum. If the to get any kind of accreditation, which is supposedly a mark of, you know, you're handling the animals in a humane way, is X, Y, and Z, then having your minimum be, the legal minimum be far lower than that, there's a disconnect there that makes no sense. So we did, in fact, use the association standards as an argument for them to at least increase the engineering standards to some degree. We weren't even asking them to breach that standard of the Alliance, for example, but just something more closer to that.
So I think we have time for one more question. I do want to tell everyone, I'm sorry we can't possibly get to all the questions, but please do talk to the panelists. We'll all be around for the next couple of days, so you will have a chance for those I didn't get to. Just very briefly, we have a number of questions along the lines of what can those of us who are interested and care about these issues, what do you recommend that we do? Should we call our legislators? Should we call USDA? So if you guys could briefly offer what you would recommend.
Since we don't know our secretary, as I mentioned earlier, yet, we have to hold out and see whether there's somebody whether it would be a waste of time or not. Certainly the other option is ensuring funding, and that would be critical regardless, and so support for those appropriations for enforcement. And it may be that certain legislators can seek to have language attached with the appropriations that would encourage better action.
I would just say, you know, self-restraint and education. I mean, I don't pay to pet a tiger. If you love a tiger, find another way to contribute to the conservation of that species.
And going back to something Anna said about how, there's an extremely diffuse and broad industry, as it were, on that pet baby tigers and all of that. I mean, that's really difficult to get a hold of because there's so many such businesses. But in the case of marine mammals in captivity, there's only a few states that have them, particularly cetaceans, but even pinnipeds, seals and sea lions. So one of the thoughts I've had for a while now is that if we could get champions who understand their state legislatures and have some, insights to their legislators, would, agree to help a national organization pursue state legislation to prohibit the public display of cetaceans or some other subset, or just orcas or whatever. So New York State's already done that. They don't have any orcas. It's really low-hanging fruit to say, let's just never let them in. And so South Carolina has such a statute for all cetaceans. New York has a statute for orcas alone. Washington State is currently working on a statute for orcas alone, actually for all cetaceans. And then California has this statute for not breeding orcas. So, if anybody else has any other state legislature that they'd like to pursue that kind of targeted legislation, even if you don't have any captive cetaceans or other marine mammals, it's a symbolic gesture that has weight, I think, and so I'm all happy to discuss that with you.
So for commercial dog breeders, I would definitely say there's no harm in sending the USDA a note in support of our rulemaking petition, which is pending. So, remains to be seen what's going to happen with it, but definitely no downside to contacting them. And on HSUS's website, there's like a draft comment that people can submit. In addition, on the local level, I would say that it's very important to try and get involved. There are a lot of ordinances being passed these days at the city and town level that restrict the sale of commercially bred dogs, and those are having a big impact and are really important. So I would say if you have a friendly town or city councilor, you should feel confident in approaching them and saying there are over 100 similar ordinances that have been passed nationwide, and just encourage you to get active on a local level.
Please join me in thanking our panel. This was a great discussion. Thanks.